Here we go. Looks like we're live. Looks like we've got some people watching. Wait for another minute till class is supposed to officially start before we go live. I'm going to post a couple links in the chat here so y'all can see those. Give me a second here while we're waiting. Okay, we posted that one. Okay, we're going to go ahead and get started. Looks like we don't have too many people on the stream. I hope people log in later and see it because it's going to be important. I'll probably need to send out a Canvas message as well, letting y'all know what's going on. Let's see. Okay. So the chapter we're covering today is chapter 34 in your text. I posted the link in the chat as well in Top Hat under the module 3. The material for chapter 16, 33, and 34 has been posted and in its shortened format onto there. I also posted a new assignment that's listed at the end of module 3. Sorry, it's not an assignment, it's for review. It is the final exam for last fall semester, okay? So that way y'all can see a final exam, what types of things we're testing on. We will be testing on the same principles in this course, except for the ones that there are a few that we covered in a little more depth and a few that we couldn't get to. So I will send out a message with the numbers of those that of the questions that will not be relevant for your final exam. But I thought you all would appreciate that to kind of know what you need to know. There will be some changes to the details, basic scenario, but the concepts tested on each question will be also tested on your final. Okay. Let's see. There will be no more quizzes or, whether attendance or content quizzes for the course since this is the last week. So really, we're just kind of going to cover the rest of the material. So today we're covering chapter 34 for real estate transfers. And then the next class period on Thursday, we're going to go over the last semester's final in more detail. And then we'll also, let's see. Anyway, so we'll just do a good review. Between now and then, because we're not doing any more quizzes or attendance quizzes, I'm going to go ahead and do the calculations of what your grade will be without the final, and get those posted onto Canvas so you can have a good idea of where you stand. And that way, if there are any discrepancies or any issues, you can let me know between now and then. I think that's it. So let's dive into our text for today. So chapter 34, the transfer of real estate by sale. We've the version posted to Top Hat is a much shortened version because there's just, quite frankly, there's a lot to take in with the chapter as it originally stood. So I shortened it significantly. So the Top Hat version, we did leave forms of ownership. Okay, there are two to three, depending on how you look at it, basic types of property ownership that we're going to remember for this class. There are other types, but not that you need to remember for purposes of this course, okay? So the first one is joint tenancy. So joint tenancy is, I'm sorry, it looks like there's a malfunction in our chat. Okay. Sorry about that. If you have any questions, feel free to text me. I don't want to give that on a public live stream on YouTube, but remember that's in our syllabus as well as multiple course messages. Anyway, so the first type of property ownership is this joint tenancy. Okay, joint tenancy is implied nowadays to mean joint tenancy with right of survivorship. So this is a true joint ownership of the property. And then if one of the joint owners passes away, the other joint owner it becomes the sole owner. Okay. Joint tenancy, rather than looking at it as a 50-50 interest, it's better to think of it as an entire 100% interest, okay? So each of the owners is entitled to the use and possession of the whole property, even though it's at the same time. Likewise, there's the dual exposure creditors, okay? So if, let's say, husband and wife own a property as joint tenants with right of survivorship. If one of husband's creditors wants to file suit and gets a judgment against husband, they can attach to the entire property. There's some exceptions that we won't cover today on that, but they can attach to the entire property. And even though wife is a joint tenant, her claim is now subject to the creditors of the husband and vice versa. Okay. So each joint tenant liability exposure is to the entire property. This happens a lot with seniors. So with seniors, they'll put a child on as a joint holder of a property, and then they'll, hoping to avoid probate, hoping to avoid court costs if they pass away. But then that child may have some kind of debt go bad or a bad business deal. And now that child has, what would you call it? Anyway, so that child's creditors now have full claim to the property. And so this senior who just wanted to add a joint owner just to keep it out of the courts, now their house is up for grabs and they can lose their house because of the actions of someone else. Okay. So joint tenancy has its problems. Generally, and for purposes of your test, we're only recommending joint tenancy if it's a husband and wife. Okay. Another form of co-property ownership, that there are two others that we removed from your text because they are just not, it's not worth testing on the principles. But another one is called tenancy in common. That's the other one that we're dealing with. So tenancy in common, rather than two people owning and accessing the whole property, the tenancy in common is really, it's almost you could almost call it a 50-50 split there. Okay, so a tenancy in common, let's say two people, whether related or not, own the property as tenants in common. They have somebody sue them, and that lawsuit is against the property. That co-owner, that co-tenant, tenancy in common, that co-tenant's interest is only 50% of the property. So they can only attach to that one half. They can't attach to the entire thing. Let's see. No, that's not one of you. Okay. So I hope that makes sense. Your text makes it pretty clear, but you need to know that distinction. Some of the other ways that we won't test on that we could have come up with property are tenancies by the entirety and community property. These both deal with marital relationships. They may or may not apply in most states, and so it's just not worth covering. Another one, however, that we will cover is they're holding property in some kind of other entity. So whether it's a trust or a business, joint ownership, unless it's between husband and wife, and even then it has its limitations, joint ownership is most effectively done through some kind of other entity. And that way the governing rules of that entity govern the co-ownership situation rather than the common law. Okay. So that's all I'm going to cover for property ownership forms for now. Okay. This 34.2 in your text with brokers, contracts, proof of title, and closing. We've taken a lot of this section out as well. I did leave in Civil Rights Act with fair housing. Excuse me. The Civil Rights Act with fair housing, we have a number of prohibitions against discrimination on the grounds of race, color, religion, sex, national origin, handicap, or family status. And it has some of those listed. Okay. The Civil Rights Act definitely affects the flexibility that people have with their property, but from a public policy standpoint, we've determined that those prohibitions are worth it in the name of public good. Okay, so just keep that in mind. That the Civil Rights Act, you'll want to read those. Types of deeds. Okay, so on your test, we'll have probably 2 questions regarding this. And I'm sorry, anyway, I'll see if I can make a note in your study guide for this. Oh, you know what? Sorry, I did cover that. So I'm going to post that study guide. So it only has 2 types of deeds listed in your text. There are actually 5 that I would like you to remember for your test. So the first one listed in your text is a general warranty deed. Okay, and this is kind of the standard type of deed for people who are making a transfer of ownership of real estate. Okay, so if you're transferring real estate, the deed is generally a warranty deed. Okay, so it has, and that warranty means that the seller or the person conveying the property to the buyer or to the new owner, we actually call this person a grantor, and then the person receiving is the grantee. But the grantor, the person who's assigning the property away from themselves to the new person, is warranting that they have marketable title and that it's clean. That means that there's no other potential questions. There's no other potential owner. And if there is, that those have been disclaimed, okay, or rather disclosed. So think about it from this perspective. Okay, let's have a house, and this house is being sold to a third party. Um, but the house is subject to an easement. Okay. Oh, I'm sorry. I really need to sneeze. That's the problem with these live courses, right? Um, anyway, so um, that's right. Okay, so um, so this house is subject to an easement. The power company has an easement over the land to access the back 20 feet of their property for utility access. Okay. Um, the the utility company has this easement, but let's say you sell your property, you don't disclose that, and somebody plans on building a building in that back 20 feet. The buyer does. Okay. You can see why that could be a problem if that easement wasn't disclosed, right? So the warranty deed basically says, look, we have this easement, but other than that, it's clean title. There's no other claims to it. So we're disclosing all the potential claims, and then everything beyond the potential claims, we're saying, look, this is clean title, this is marketable title, and it's coming without any problems or encumbrances of any kind. Okay, um, that is completely different from a quit claim deed. Okay, so the quit claim deed is not making any assurances, any promises as to the marketability or utility of the title. It's basically saying, look, any claim I may have in it, which may be none, is transferred to you. Buyer beware. Okay, but so we use quit claim deeds quite often in cleaning up title. Okay, so as an example, we'll have, say, um, let's use a person, John Smith. Okay, John Smith has a property and he sells it. Okay, and then so he received title when he bought the property. He received it as John H. Smith. Okay, John H. Smith, and he has the middle initial. And then when he conveys the title or when he sells it, he conveys it as John Smith without the H. Okay, that creates a problem with title and the chain of title over time. And so rather than having him have to do another warranty deed, because he can't really warrant or claim there are no defects because he's created this defect, right? So he may instead do a quit claim deed, and that quit claim deed is what we use to clean up title. And so he received it as John H. Smith. He conveyed it away as John Smith. So we use another quit claim deed to clean up title and convey it as John H. Smith as well, so that there's no John H. Smith that could come along and claim this later. I'll be sorry about that. My it's that time of year. My allergies have never been worse. So um, anyway, sorry about that. So um, anyway, so we have our John Smiths, and then okay, so that's only two types of deeds. We have a few others. Okay, so there's a trust deed. A trust deed is different. A lot of people think, oh, a trust deed, that must have something to do with a trust, like if you're doing a last will and testament and a living trust or something like that. And that's not the case. Okay, so a trust deed is a deed used to evidence alone. Okay. So if you've ever taken out a mortgage, you sign a trust deed because you're not giving them the house or the legal title to the house, but you're signing them evidence of a loan, and you do that through a trust deed. Okay. There's also the deed that cancels out a trust deed or evidence that the loan has been paid off. That's a deed of reconveyance. This will be in your study guide. And then the final type of deed that I want you to remember is a special warranty deed. So it has, it's like a warranty deed, but it has some kind of limitation or other quality that it's a qualifying quality. So it's not going to quite have the same weight as a warranty deed for whatever reason. In Utah, these are mostly used for water rights. Okay, so if you have water, you can't convey a warranty deed necessarily, at least not under the common law, because ultimately those claims are subject to the state. So instead, they will issue a special warranty deed. So just keep that in mind. So those are the 5 types of deeds: general warranty deed, quitclaim deed, trust deed, deed of reconveyance, and special warranty deed. And these will all be in your study guide. Let's see. Proof of title. There's a little bit of information about proof of title and chain of title here. Abstracts and opinions, title insurance. I've left that in there. I'm not going to test on these in particular, but they are really important from a background standpoint because many of you may end up working in the title industry, especially. So, for example, this proof of title. How do we know who owns what? Right? We have to have some kind of evidence. Proof of title is one of those. So if you go to like a county recorder website and you see who owns the property, it'll have the deeds that gave that person the title to the property. I've alluded to it in recording statutes in this section here. There are multiple sections that I deleted because there are different versions of recording statutes. I don't want you to remember all the different types of recording statutes. I just want you to understand that basically that in general, when somebody records a deed, it becomes effective. If there are 2 deeds for the same property, there may be a difference in whose deed controls based on when it was recorded, when it was written, who knew about what, when, that kind of stuff. And so we don't need to get into all of that. Chain of title. So if you have a property and you want to know, this chain of title and abstract of opinion are kind of like the genealogy of property ownership, right? So we're looking at who has owned it in the past. Is that chain of title clean? Meaning, are there any claims that have arisen that haven't been dealt with? Have all the people signed off on it, or court process has been done that are necessary in order to make sure that the person who is selling the property truly has the authority to sell that property. So that's what all this stuff is about. And then title insurance is one of the ways that people can insure that risk. Very common, actually required in most transactions. If there's a loan, especially if there's not a loan on the property, it's not necessarily required, but it's highly advised. So if anybody else has a claim on a property, the title insurance comes into play to say, look, sorry, you didn't actually own this property. This claim has arisen, but we're going to compensate you. Okay. And that's it for this chapter 34. check my phone, see if we had any questions, since this chat doesn't seem to be functioning properly today. I don't see any questions. Okay, so I will get that study guide ready for you all for the final, and then we'll review all of those concepts on Thursday. If you have any questions, let me know, and we'll get your grades all adjusted and put in except for the final, so you all know where you stand, and then you can contact me about that as well. Let me know if you have any questions. Thanks.